Hi guys, it's Kathy. I hope you're doing well. Thank you for the extra 30 minutes this morning. I appreciate it. Today we're saying stupid EKG, even though it has nothing to do with me. But we listen to EKGs because they're important. Tell you about your heart. You gotta listen. But it still sucks. Anyway. Don't worry about that. Someone understands. Today we have a litany of crazies, which fits right in with us. Here we go.
Mr. Walsh, let's go back to you, sir. We'll have you come up to the podium. It's case 26M49.
I do apologize. I had a time. I'm sure it's not tucked in. I apologize, Your Honor.
No, not necessary, but thank you for explaining the urgency of your arrival and departure and return. I'm glad to hear you got your pet back. So let's get to the serious nature of the case today. You are representing yourself still in this case.
I have just been unable to find representation. I guess I can file for a public defender. I mean, I personally am comfortable defending my First, Fourth, Sixth, Eighth, and 14th Amendment rights, though.
Are you comfortable doing that, sir? CJ, don't leave. I gotta go get something. I'll be right back, but CJ, don't leave.
If I have to, pro se.
You have the right to represent yourself. I'm not telling you to get a lawyer. I'm just summarizing the status that you are representing yourself still.
Correct.
You have filed a motion to dismiss that is complicated.
Quite.
Some of the allegations are alleged state violations of your federal constitutional rights, and those have to be addressed through a federal lawsuit. Some of what you've addressed goes to whether or not the Colorado statute is unconstitutionally overbroad or vague in that it prohibits your right to freedom of speech. Those motions may require you to provide advance notice to the Colorado Attorney General if you are arguing that the Colorado statute is unconstitutional.
Yes, Your Honor.
If you are arguing that it is unconstitutional as applied to your case, you still have to notify the Colorado Attorney General so they can enter on the case and argue why, in fact, that statute is constitutional. The prosecution obviously has a right to respond to your motions. Today is not set as a motions hearing, so we're not going to resolve the merits of your motion today.
Okay. Well, thank you.
You will have a chance to be heard. I just want to go through what I had prepared to tell you as to the status of the case. As the judge, I do not have the authority to choose to dismiss the case. You have to prove a legal grounds for dismissal, and that would be done at a motions hearing, which is not today. The prosecutor seated behind you determines whether or not the charge has merit, and he gets a chance to review your motion and prepare and then present his arguments at the motions hearing. So right now, you can plead to not guilty and we'll get you set for trial. We'll set a motions hearing date. You can choose whether or not to continue representing yourself, though it is advisable to get a lawyer. People now are choosing to use AI or do their own research to help them prepare, but it is still advantageous to have a trained attorney represent you in a criminal matter, especially one in which you are facing a potential jail term, such as this case. So you mentioned you could apply for the public defender. I was not trying to pressure you into that, but it is an option.
Your Honor, I understand representing yourself in an emotional case like this where the government has violated so many of my rights for so long. I definitely will not benefit representing myself. It would be more advantageous to have a public defender. Really anyone that can read the Bill of Rights and argue for me. Because I'm emotionally invested. It's going to be difficult for me. So I will apply for the public defender. I will also, for the motion, I'd like to set the motions hearing because I will also be filing a counterman v. Colorado argument, the reality of true threats versus not. I'll argue that. I apologize. I didn't have my phone all weekend. I obviously meant to come here early, but my husky that I just adopted can chew through everything. So he has to be permanently on a chain. Today was the one day I didn't put him on a chain. Horrible mistake. I apologize. And then I'm also going to be following that anti-SLAPP motion, which I know I have to do within the next 32 days. So with both of those motions, I will be filing as well as that other motion.
Okay, when I mentioned the option,
I will never file an anti-slap motion, ever. I believe in slapping. CJ, look what I got at the store. Australia's Violet Crumble. It's the way it shatters that matters. Now, is this a real thing? Or did I get duped? Is this real? Is this like a normal candy bar in Australia? Violet Crumble. It says something about honey. Hold on. Honey, honey, honey. I thought it said something about honey. Delicious, shattering candy, honeycomb. Is this, but like, do you eat this? Hold on, I can't break a piece off to see the inside. It's like nougat. It looks like nougat. Oh wait, no it doesn't, it's hard. But I'm gonna try it and I'll tell everyone how it is. It might not be like popular in Australia. It just says Australian candy, so I thought maybe it was something popular in Australia. Alright, back to the craziness, guys. Wait. Kelly, thank you so much. Thank you so much.
of setting this for trial, you nodded affirmatively. So do you wish to enter a not guilty plea today and request a trial?
Yes, Your Honor. I would like to invoke my Sixth Amendment right, say that I am not guilty and start that 6-month timeline right now.
And would you like to elect a jury trial or a court trial?
Jury trial, Your Honor.
I'm going to go ahead and pick a date. We are going to give you the public defender's next appearance.
Sodak. It's delicious. It really is. Kristen, did you see that guy yesterday? I think it was yesterday's stream. Had charges in Minnehaha.
To see if you qualify. They can print that out for you down the hall. His contact information is in the corner, Mr. Toffer. You can text him and he'll help follow through with the application instructions.
Your Honor, I would also like to just state for the record, I'm going to be filing a motion for sanctions against the district attorney because their contact information on their website lists a poodle and the phone number is 555-555-5555. I have been unable to serve
Please do not call that number looking for a poodle.
these people with any sort of paperwork because their contact information is very unprofessional and you can pull that up on their website right now, Your Honor.
Okay, let me.
I'm sorry.
Let me come back to
I'm
that.
so sorry, Your Honor.
So
When I saw that, it pissed. I'm sorry to say this in your court. It pissed me off so bad. I sent it to everyone in the county. I'm like, this is our district attorney. He's a poodle. It's very unprofessional, Your Honor. And I have a legal obligation to send motions to them, and I've been unable to do so.
Okay, let's take things one at a time, Mr. Walsh. The court accepts a not guilty plea, request for jury trial. The jury trial is set for September 17th at 8:30.
Is that in the morning, Your Honor?
Yes.
Okay.
Yeah. When typically we can do a one trial day, but we'll hold the Friday open if it needs to go longer. We're going to set the next court date for June 3rd at 10 a.m. They can print that out for you down the hall. It's a week from tomorrow. Contact Mr. Toffer by text. His information's on the, not Mr. Matthews.
Okay.
The public defender, on the corner of your application, there's his phone number there. Yes.
Okay, yes.
Send him a text. He'll get the application process started. Try to do that before your next court date.
Okay.
Nice. 49.
And then prior to June 3rd, Your Honor, I just want to get all my motions filed, like how soon prior to that date?
Motions will be due probably July the 2nd.
Well, for our motions hearing, we said June 3rd, right?
No, that is for application to the public defender.
Oh, okay, I apologize.
So let's assume you qualify for the public defender and after talking to him, want to accept their representation. Your public defender will go back over your motion to help you prepare with legal advice to present that motion to the court. So when you show up on June 3rd, we're going to find out if you get the public defender. If you do, then we'll set a motions hearing. If you don't, we'll set a motions hearing. We're still not going to do your motions next week. The DA gets more time than that.
Okay.
So for June 3rd, we're going to schedule appearance of counsel, see if you qualify. We're going to set a motions deadline. The public defender may have additional motions that he wants to file. But he needs time to get the information about your case to properly help advise you as to your options.
The only other thing I was concerned with, Your Honor, is I had employment outside of the state, which I can't obviously go do now. And I can't move my nursing license to Colorado with a pending charge. It's just very ill-advised. My bond is $2,000, which was all of my savings. I am in need of money. My truck needs repair. I'm not going to leave the state. You've seen me before, Your Honor. I'm not going to go anywhere. I'm just requesting somehow, some way I can get some of that money back. Just, because my resume is, nursing, I cannot get a job in Park County. No one is hiring me. I'm overemployed. They know I'm going to leave as soon as this case is dismissed, which it will be.
Listen, nurses. Nurses, listen. It's okay. Every profession has one. Okay? So you have one. You have this guy. There's nothing you can do about it. It's okay. We all, look, as a server, I have millions of crazies that are servers. You have one nurse. It's fine. He's not employed.
Okay, Mr. Matthews, there's a request to modify bond. Currently, this is a $2,000 cash bond posted by Mr. Walsh.
Poor CJ. Anytime we have anything slightly Australian, we nail her with it. Oh, look. What does this mean?
Mr. Matthews, any objection to converting this to a personal recognizance bond and/or reduction of bond?
One moment. Yes, Your Honor, the defendant is charged with harassment, and he has a conviction for DUI in 2012.
I can't buy food, Your Honor. I'm just going to be honest.
A deferred and dismissed harassment in 23.
20 what? That wasn't a real word. So harassment. He's charged with harassment. He had a deferred harassment. Oh, deferred. So he finished his probation and it was dismissed. But I didn't know if it was 2003 or 2013. I couldn't understand him.
That was 3 months after my father's suicide.
And he could be a flight risk.
He's not a flight risk. No.
Your Honor, I believe in the Bill of Rights so strongly, I will never leave this fight.
All right, Mr. Walsh, these are quotes from the arrest warrant. They are unproven, but
Okay. Guys, there's some foul language coming up, all right? Just warned ya.
they constitute the evidence presented to the court as to why there's probable cause.
Okay, in the future, when you say any of these words, try to say them as slowly and calmly as this judge is right now, okay? I will look at it. CJ, I will look at it.
To suspect that you may have committed harassment. Right. And I don't like quoting these, but I think it's important.
Your Honor, there was one night where I'm not proud of what got said.
Anything you say is recorded and maybe used against you. But this is why I have concerns regarding community safety. Hey, fuck WAD, fuck you, and fuck the government. Fuck you, loser. Fuck you, faggot. Government dick sucker. Government fucking.
Your Honor, after 8 months.
I don't want you to interrupt me for a moment, okay?
I apologize.
Let me know, bro. If you want to fuck with me, I know where you live.
Yeah, I had to delete one word.
That's a threat as alleged in the warrantless arrest. I wish death upon you. How do death wishes feel? Hope you die, loser. So this is a serious case in the court's opinion. These are not statements of...
That just sounds like Saturday morning breakfast, Judge. I don't know why your panties are in a bunch.
Free speech as alleged in this document, as far as saying that the government sucks or you don't believe that they are conducting themselves in an appropriate fashion, or that you feel like you're being harassed by the government, which obviously that is underlying sentiment here. But if proven, and if this is evidence presented directed at a particular individual, it is of course concerning, and that person would have obviously a reason to be concerned for their safety. So I'm sorry, I know you chose to post the cash bond. You could seek the assistance of a bail bondsman. You can revoke your own bond and get a bail bondsman to post that bond for you. I think this was a cash or surety bond option. That would be a way to access some of the money. It's not ideal, of course. But based on these allegations, the fact that you do split time in California and Colorado, the prosecutor is concerned about a potential flight risk. I am not going to modify your bond.
I don't understand what the whole modifying the bond was for. He already bonded out. He paid the $2,000. Maybe he just wants the money right now? He wants it back?
So I'm not going to go look at the DA's website. You've raised your concern. Mr. Matthews has heard your concern, and if that is factual, hopefully something would be done to remedy that, but it's not my place right now to look into that. So
no, the government doesn't, never mind. Government, never mind.
Contact the public defender. I'll see you back here next week at 10 a.m. We'll find out if you get the public defender to assist you, if you want them to enter after talking to him.
Yeah, I'm not worried about a jury trial. I just hate that we're going to go through all this process. All he had to do was send me an email, Your Honor.
Okay.
No, he doesn't have to do anything. You broke the law, sir. You're going to go to jail. You need to worry about you right now, not the puppy on the DA's website, which clearly is them just... Clearly that's not real, sir. You need help.
Be that as it is we've got you scheduled for jury trial.
And for anybody listening, know the DA in, I don't know where this is. I know it's Colorado, obviously, but I don't remember which county. The DA in that county is not a puppy. It's just not. And his phone number is not 555-555-5555.
Speedy trial clock's running. You've got the public defender to talk to see if you want and qualify for legal assistance. I'm not telling you to get a lawyer, but my job is to advise people that it's advantageous to have a trained criminal attorney, because I can't give you legal advice. I can't make exceptions for you for not being an attorney. Obviously, you're doing your research, and that's good. But you can talk to the attorney and see if you want them on your side, okay?
Yep, thank you, Your Honor.
Head down the hall in just a moment, Mr. Matthews.
Your Honor, did we set the pretrial readiness conference and a motion hearing date?
I was going to do that next week and see if Mr. Toffer's here for those dates
Okay, that makes sense.
before we get those on the calendar. So down the hall, they'll print out your next court date. Please contact Mr. Toffer. If you qualify, you can decide for yourself whether you want them to join on your side. We'll see you next week.
Cool.
Okay.
Thank you, Your Honor.
Thank you.
Is Mr. Aragon's case going forward with a plea? Mr. Zane?
I don't have one yet. We were still waiting for VRA, I think.
Okay. Is that correct, Mr. Bullock?
Judge, I'm not prepared to go forward with the plea. And in fact, the offer, I anticipate I will withdraw.
For what reason?
Okay, give me just one moment. Mr. Aragon, if you could come forward, we're going to address your case or cases. Those are 25 CR 37 and 25 CR 100. I note the appearance of Mr. Bullock on behalf of the people. Patrick Aragon present today in person. He appears with his attorney of record, Russell Zane, and we were scheduled for plea hearings. Mr. Bullock, do you want to make a record?
I certainly do, Your Honor. Your Honor, at the time that I appeared at the last proceedings, my office had not had victim input in regards to the plea, and we were not in compliance with the Victims' Rights Act. Since that time, I've met with the victim. Based upon my conversations with him, I do not believe that the offer that had been extended was appropriate, and I would withdraw it at this time. I understand that may trigger some
It's going to trigger a hissy fit. That's what it's going to trigger.
filings by Mr. Zane, but I do not believe that the offer that was extended certainly was not appropriate.
Thank you, Mr. Bullock. Mr. Zane?
I know it's kind of weird how you say it's not appropriate and then make your own stipulation to probation and no jail on top of the offer that was extended by a different deputy. This makes no sense to me. This offer is perfectly appropriate. We've detrimentally relied on it. And here we are, and they're just pulling it for no real reason other than they didn't do their job right the first time. This is not Mr. Aragon's fault. This is highly frustrating. We worked a long time to get to this disposition, and now we have to pay the price because they never bothered to consult with the alleged victim. Like, I'm just real tired of people not following through with what they say they're going to do. And that's been happening a lot here. I don't know what the reason for that is. I'm sorry. The parade of deputy DAs that have come through here have been horrifically incompetent and been fired. But, you know, that's not Mr. Aragon's fault. It's not my fault. It's not the court's fault. We've been waiting to do this plea for months now. So I will be filing something along these lines because of this. I just tell the court I'm very frustrated and very sick of it.
How much time do you need to prepare
Well,
a motion or brief with respect to the issue?
let's see. I got to brief the court backing out of a PR bond on a homicide case last time we were here. Now, apparently, I have to brief this where the DA is backing out of an offer that was made and set over so we could get paperwork like 5 times. Probably going to need at least 30 days.
And Mr. Bullock, how much time would you need to respond to the motion?
2 weeks.
The court will grant to defense counsel 30 days to file a motion with respect to the withdrawn plea agreement or plea offer. That will be due on June 26. I'll grant to the people 14 days to file a response. That will be due on July 10, and the court will set the matter on July 14.
Okay, here's what I think. So I think the lawyers are paid to overreact. They get better results when they overreact. But that doesn't mean there's no truth involved in what he was saying. I think maybe one district attorney has been fired in the past year, 2 years, or whatever, because they weren't good enough, and now he's using it in all of his cases. But I don't know that. Okay, this next one, guys, is very short. It's a crime we don't hear often, thank goodness. But what did she do? They don't tell us what it was. Her and her friends. What did they do, I wonder? Or maybe I don't want to know. I might not want to know. But you're going to have a bunch of questions after this.
Carla, can you hear me okay?
Yes.
The high charge in your case is tampering with a deceased human body. It's a class 3 felony. It carries the possible penalties of 4 to 16 years in the Department of Corrections, a $3,000 to $750,000 fine, and 3 years of mandatory parole. Your mandatory protection order includes the provisions I went over earlier with everyone. Do you acknowledge and understand those provisions of your mandatory protection order?
Yes, ma'am.
If you were to violate any of the provisions of your mandatory protection order, additional criminal charges could be brought against you, and you could also face proceedings in contempt of court. Do you understand that as well?
Yes, ma'am.
The recommendation I have here is for a PR bond with no pretrial supervision. Ms. Butterfield.
I am objecting to that recommendation. I would note that the two co-defendants who are charged with the same charges, one still has an active warrant. The other one had her bond set at $100,000 cash only, which I believe the active warrant, that's the bond that was set when the warrant was signed. I'm just asking the court to keep the bond at that amount in line with the similarly situated co-defendants.
Thank you. Ms. Wood.
Your Honor, this is a conflict for office, so I'm not able to speak on her behalf.
Thank you. Ms. Barella. You have the right to remain silent. You do not have to say anything before I set your bond. If you exercise your right to remain silent, I will set your bond based on the information I have in front of me. If you choose to address the court regarding your bond and waive your right to remain silent, please do not say anything about the facts of your case, because anything you say here can and will be used against you. The Public Defender's Office would normally be representing you today because you are in custody. However, I've been told by their office that they have a conflict of interest and are unable to represent you. I do not know the nature of the conflict, just that they have a conflict preventing them from representing you. You always have the right to hire your own attorney at your own expense if you are able to afford to do so. In the alternative, the court can appoint an attorney to represent you at no cost so long as you are in custody, or if you are out of custody and qualify under state income guidelines. Do you understand?
Yes, ma'am.
Would you like to remain silent, or would you like to say anything regarding your bond?
No,
Whether-
I was silent.
Okay, thank you.
Am I done?
Well, hold on. I'm going to set your
Okay.
bond. Give me 1 second. I've considered the information, the affidavit, the arguments of the Deputy District Attorney, the information read to the court by the CPAC workup, and the purposes of bond. The court will keep the bond that was already set by the probable cause judge, Alexander. That amount is $100,000 cash only. Ms. Barella, your next court date is June 1st at 1:15 p.m. in Division 404.
Okay, thank you.
Thank you.
I don't know what she did. I have a million questions, but here's what I think. This is just a guess, a wild, wild guess. There was a murder, probably someone in her friends group committed a murder, and she helped get rid of the body in some way that she got a charge for tampering with a corpse, like, you know, chopping it up or something. So that's what I think. I mean, she could have done, they could have been like grave robbing. They could have dug up a grave to rob it, whatever. That's tampering with a corpse. But I don't know. I think that they committed a murder, called their friends, help me hide this body, and they all got caught. We're going to find out, though, because there's no way that I'm not going to get at least one of them soon that says more. Okay, this one, I thought I played this before, but I couldn't have, because it was just made yesterday. All right.
People versus Nicholas Sprague, 26M125, I'm sorry, 1241, 25M3581. Mr. Sprague appears. One of these cases is set for trial and set for motions hearing in about 5 days, I think. Ms. Page appears on his behalf, and Mr. McCall appears on behalf of the people. Yes, ma'am.
So I don't know
I will always help you hide the body, always.
if the court has seen my motions that I've filed in.
No, she wasn't charged with murder. She was charged with tampering with a corpse,
The first.
No,
which is just a charge we never hear. So this hearing right here we're listening to is sort of a little dry and boring. It's not long, it's short, until he starts to speak. Once he starts to speak, everything changes.
is the answer to that question, but that doesn't mean I can't.
Okay, so I can check. I believe actually the court might have issued an order.
I issued pile of
review.
orders yesterday.
Or it was a long time ago. Let me just pull up the exact case
Could have
number.
been
So it'd be
grave robbing.
25M3581. It was a. Let me pull it up before I start talking about it.
It's a rule under 16.8.5.
Yes.
102. By the way, the governor signed into law the new House bill, which changes the rules completely.
He talks about a new law that the attorneys don't know about yet, so that's pretty interesting too. But I want to see your motions too.
On mental health concerns. I had reserved ruling, but I can address it now.
Okay.
So it was one case, I think it was Ms. Spencer's case actually, where I didn't think there was enough.
There were two of them.
One I issued an incorrect order, I remember it very well, and
This one was, we were going to address it in court at the motions hearing, but now I think we can just vacate the motions hearing and have that right now, if the court would like.
okay. Yeah, I can enter an order.
Okay, thank you.
I'm sorry, I can't hear, so I don't know what's going on.
Oh.
But
Let me help you out. Do you need hearing assistance?
Hearing, do you want like a
No, it's
microphone?
plugged up with wax or whatever. I was
Okay.
trying to get it.
He has earwax, Judge. Judge, he has earwax. He can't hear you.
If I speak up, can you hear?
You know, it's every now and then. You know, I can hear out of this here, but you know,
Okay. Well, if you
it's
turn,
it's like a perception type thing too. You know, like like weight. You know,
okay.
it's like gravity type thing. You know.
So there's been an issue. What's been raised here? I'll just do it as a standard advisement. Give me 1 second. Okay.
So I feel like most of these. Well, I know all of these cases are. They've tried to falsely incriminate me, and I don't know why. All the police tried as 6 officers on a homeless person with a Puma bag. How does that make any sense with 6 blankets?
So a question's been raised, Mr. Sprague, about
Terry, him. This is just like the meme you put in Discord. Well, the story you put in Discord. 6 of them against him. 6 officers against him. He lost, though. You won.
your ability to either consult with your lawyer with a rational degree of understanding or have a rational, factual understanding of the proceedings against you.
Whatever.
So what I'm going to do is suspend proceedings in this case. You have a right, and I'm going to have you undergo an evaluation. You have a right to have counsel and a hearing on whatever determination is made as a result
Do I
of
get to
the,
choose the counsel?
you are assigned appointed counsel, in this case, Ms. Page.
Okay.
If you have questions with that, you can ask for a status of counsel hearing, but typically I don't do that until competency proceedings are completed, or at least the evaluation.
What is
It's
the question
completed.
with my competency
The question is.
and
when-
why?
Well, it's, the question,
What
the
and
question is whether you have the
Judge, just roll back the tape. Just roll back the tape of this hearing and he'll understand.
ability to consult with your lawyer with a reasonable degree of rational understanding in order to assist.
Why would I not have it a reasonable degree?
Well, that's what we're going to find out,
Okay.
right? And whether you'd have a rational, factual.
What is the criteria for judgment?
Well,
Before or whenever I enter these proceedings, I must know the criteria.
there is a brand new statute, right? One that was signed into law by the governor last week,
Okay.
right? The criteria, I don't believe has changed for this, right? Which is, as I said, I covered the first one, or for you to have a rational and factual understanding of the proceedings against you. I would make that determination after I'm assisted by an evaluation, perhaps more than one evaluation of your competency. And that's typically done by a psychologist or a psychiatrist.
What is the criteria they're using to judgment?
Well, I just gave you the standard.
You said a psychiatrist or a psychologist would judge me. You didn't say what.
We'll
their
do an
criteria-
evaluation of you. They don't judge you. That's my job. My job is to enter judgment.
Your job is to enter judgment.
Right. I make determinations.
With the opinions or the qualifications of somebody who's professional of something else.
Exactly right.
You're saying you don't know their criteria.
I'm saying I just gave you the criteria.
Well, I must have.
I'll just read it to you.
Okay.
That whether you have the ability to A, consult with your lawyer with a reasonable degree of rational understanding
Okay.
in order to assist you in the defense. That's A.
So
Or B, if you want me to explain
with
the
my lawyer, I'll get to qualify this with my lawyer, with her
Correct.
words and my words, correct, or whatever.
Right, you'll be interviewed.
In the presence of a psychiatrist or a psychologist.
Correct.
Okay, it's not going to be simply a mental examination of me, per se, but the relationship of me and Alexis.
Well, what the key issue is whether.
Oh no, sir. They're going to evaluate you and judge you. Yes, that's what they're going to do.
You have an idea of of whether you have the ability to assist her, or whether you have B, a rational and factual understanding of the proceedings against you.
Well, all I know is I don't want to be medicated against my will
I'm not going to medicate you against your will.
at all. I don't want to be medicated at all.
I'm not going to medicate you against your will.
Okay. All right. Well,
Right? That is done.
we can
That process is
from there.
done.
I just
Sir, that was never on the table, but now that you mention it.
don't, and also I don't want to be made to found mentally incompetent or something when I'm not.
Right. So somebody.
My father would have forced my hands to say that I was mentally incompetent when I was mentally incompetent because of the medication I was taking.
I'm not going to force you to take any drugs.
So I'm just telling you.
That process is available.
I have a lot of trauma from that kind of crap or whatever.
Okay, yeah, so the court hereby stays the proceedings in this matter. I will authorize the issuance of a competency evaluation. I'll continue with the advisement. If a final determination is made that you're competent to proceed, we'll just move the case along. If the determination is that you're incompetent to proceed, I can either release you on bond with conditions or keep you in custody and send you to the
Is there some
Department of
point where I'm
Justice.
supposed to fear for my life or something or whatever?
No, I do this all the time.
Because, it's my life. It's
I
my
have a-
life. I get to choose or whatever. I'm not afraid of officers shooting me for no reason because I'd rather be dead.
Okay.
That must be your issue because I had guns faced, twice in my life here in Colorado. Never have I even seen a gun. Never have I even seen a gun, man. And I had guns pointed at me twice here in
Okay,
Colorado.
Mr. Sprague, here's what I'm gonna do. I'll set you out 3 weeks or 6 weeks to figure this out.
So I was going to try to address this $500 bond as soon as possible. It's a
I was
VR
hoping to get
case.
to stay outside.
What? Lady, did you not hear anything that's going on? He's going to Susan Blanco. You're going to have to talk about bond with Blanco because he's definitely going for competency.
It's not healthy for me to be indoors, sir.
And so given that
They're here.
Are the people on notice?
the Mr. Brown is on notice that I intend to argue it, but not today, that I intended to argue it at the soonest possible date that he is.
I'll set it over.
I'm also attempting to find housing in town.
Oh, we're going
It's
to
a
give
menacing
you,
case, it's VRA, so
they're going to give you housing. Don't worry. They got you.
I'm not going to give him tomorrow, but I'll give him Friday.
Okay, thank you, Judge.
This case is set for Friday, May, whatever Friday is, 29th.
Thank
See you
you.
on Friday afternoon, 1 o'clock in the afternoon, Mr. Sprague.
Okay.
Thank you.
That's the competency.
That's just a hearing to address bond.
Sorry?
That's a hearing to address bond.
A hearing to address bond. Okay.
Okay,
All right, man.
thank you.
Thanks.
Yeah, he's about to go to a different place to get better. All right, don't worry. The sound will be on in a second. Don't nobody tell me, oh, I can't hear anything. I know, it's fine. The judge has it muted for a second.
Criminal call is May 4th, 2026. The state is
I left the muted part in so you could see her flirting with the guard.
represented by Deputy Prosecutor George Galanos and Pro Tem Judge David Ambers is presiding. Mr. Galanos.
Good morning, Judge. State of Indiana versus Caitlin Fanai, 2605F6477, initial hearing.
Thank you. Ma'am, are you Caitlin Fanai?
Yes, sir.
Am I pronouncing that correctly?
It's okay. It's pronounced Finai, but it's okay.
Fanai? Okay. And how old are you, ma'am?
I'm 29,
All right. And where do you presently live?
16, Michigan City.
And did you read or see a video of your rights this morning?
I did, Your Honor.
And do you have any questions about those rights?
I do not.
Okay. Listen to the prosecutor as he explains what you're charged with and the possible penalties, please.
She is charged by way of information that alleges that on May 1, 2026, LaPorte County, state of Indiana, the defendant did then and there unlawfully, knowingly, or intentionally, without a valid prescription or an order of a practitioner acting in the course of that practitioner's professional practice, did possess cocaine, pure or adulterated, or a narcotic drug, pure or adulterated, classified in Schedule 1 or 2. It was 0.2 grams of a gray powder substance which field tested positive for fentanyl. That's a level 6 felony. A level 6 felony is 6 months, 2.5 years, Indiana Department of Corrections, $10,000 fine with a presumptive sentence of 1 year. Also charged with on that same date and time with possession of methamphetamines, pure or adulterated without a valid prescription, order of a practitioner acting in that course of the practitioner's professional practice. It was 0.4 grams of a crystal-like substance which field tested positive for methamphetamines. That's also a level 6 felony. And she is also charged with, on that same date and time, with possessing an instrument, a device, or another object that the person intends to use to introduce into the person's body a controlled substance, testing the strength, effectiveness, or purity of a controlled substance, or enhancing the effect of a controlled substance. That is a Class C misdemeanor. Class C misdemeanor is 60 days in LaPorte County Jail and a $500 fine. And that charge has been elevated because the person has a prior unrelated conviction under that section, and which makes it a Class A misdemeanor. Class A misdemeanor is 1 year in LaPorte County Jail and a $5,000 fine. We'd like to be heard on the issue of bond.
Ma'am, do you understand the charges and the possible penalties?
I do, Your Honor.
All right. Mr. Prosecutor, with regard to bond?
Judge, she's currently out on pretrial release under 2502 CM 495 for theft as a misdemeanor. Asking for $1,000 cash bond.
All right, ma'am, given your criminal record, the court deems you a danger to society and is setting your bond at $1,000 cash. Any questions?
Is there any chance it could be lowered? Probably.
No, man. Given the
Okay.
fact that you're out on pretrial release, the bond's gonna be $1,000.
Okay, thank you, Your Honor.
For May 29th, so we'll keep that vacant.
So you'll come back, your other case apparently is set for May 29th, so we're going to set these charges with the other case.
Okay.
Thank you.
Thank you.
State of Indiana versus Ashley Arndt, 2506 F6 683, 2604 CM 947. Have you heard any issue of bond?
She wants it, they want a 15-day hold, so we don't have to address.
Okay. Ma'am, I'm sorry? Are you Ashley Arndt?
Yes, sir, I am.
Ma'am, are you aware that a second petition for revocation of suspended sentence and a third petition of revocation of suspended sentence has been filed against you?
I just thought, I don't know, sure. It's really confusing after a while.
Listen to the prosecutor. He's going to explain the two petitions for revocation to you.
Okay.
The second petition to revoke probation was filed, which basically states that on November the 10th, 2025, this court imposed a suspended sentence and placed her on probation. As part of being put on probation, Your Honor, she was given conditions of probation that she acknowledged in writing. Condition that she acknowledged was condition number 1 in writing, in that it states that you shall refrain from violating any law, federal, state, or local. And furthermore, shall advise the probation department within 24 hours if charged with a misdemeanor or a felony. On April 21, 2026, the defendant allegedly committed a new offense of criminal trespass as a Class A misdemeanor under 2604 CM 947. Condition number 4 that she acknowledged in writing, you shall report for probation appointments as directed by the probation department. If your sentence includes a term of incarceration, you shall report to the probation department within 3 working days of your release from incarceration. On February 2026, the probation officer spoke to the defendant via telephone and instructed her to contact probation if the court agreed to recall the warrant issued for her first petition to revoke suspended sentence. That warrant was recalled on April the 7th, 2026, and she failed to make contact with probation and has not reported to probation since December 29th of 2025. That's the second petition. The third petition,
Guys, I'm sorry, but whose birthday is it? It's May 29th. I know that it's one of your birthdays. And I asked this a couple months ago, whose birthday is May 29th, because I can't remember. Somebody has a birthday today. Happy birthday. I just don't remember who it is.
Judges placed on probation on November the 10th, 2025. She was given written conditions of probation that she acknowledged. Condition number 1, refrain from violating any law, federal, state, or local, and advised the probation department within 24 hours if charged with a misdemeanor or a felony. On March 23rd, 2026, she allegedly committed a new offense of battery resulting in bodily injury as a Class A misdemeanor and is charged under 46D03, 2603 CM 722. Condition number 5 that she acknowledged states you shall not knowingly associate with individuals that are in probation, parole, or involved in any illegal activities. On March 23rd, 2026, she associated with a Stephanie Martz, who has a legal history in LaPorte County. Ms. Martz is out on bond for felony matters pending in circuit
Happy birthday, Sandra. Happy birthday, happy birthday.
court.
You understand the two petitions that have been alleged against you, ma'am?
Correct. Yes, I understand them.
All right, it's my understanding probation's asking 15-day hold? No?
It's the next one.
Okay, I take that back. State wish to be heard on bond?
Judge, she is currently on probation under 46C01 2210 F6 1389 for theft as an F6 felony. She's on probation under 46C01 2309 F6 1271 for theft as an F6 felony. She's currently on pretrial release for 46D03 2603 CM 722 for battery resulting bodily injury as a misdemeanor. And we have
I didn't know about that one. Like I literally didn't know about it at all. For that, whenever I got arrested and no one said anything, I had my 12-day hold or 14-day hold, and I just came here for a bond. if possible.
Ma'am, let the prosecutor speak, please.
Sorry, I'm just so confused.
She also has a current charge.
You didn't just come here for a bond, ma'am. This is court. I just came here to get your roast beef. I don't know why you're dealing with all this stuff. I just want your roast beef sandwich, please.
In this court under 2604 CM 947 for criminal trespass is a misdemeanor. Judge, we're looking at a $1,500 cash bond. She has been convicted of multiple felonies in the past.
Any FTAs?
I'd have to check, other than not reporting to probation on a suspended sentence.
Okay. Ma'am, I agree with the prosecutor, given your legal history and the number of charges you have pending, the court's going to set your bond at $1,500 cash.
So that means no bondsman? I know, I'm just curious.
No, it's going to be cash only.
Okay, thank you.
Thank you.
F6, correct, Your Honor?
We'll set for
I'm sorry.
June 29th.
I'm sorry, ma'am. You're going to be reset to June 29th at 9 a.m.?
Your Honor, that bond was for the F6, correct?
I'm sorry?
That bond was just for the F6? The red?
Yes.
Thank you. All right, thank you.
Yeah, well, she has 2 cases.
I'm sorry, it's cumulative for both of her cases.
Aggregate for the criminal trespass as well, thank you.
Correct. I'm sorry. You gotta let me get back in the swing here. Go ahead.
State of Indiana versus Jazari Walker, 2604 CM 972.
Are you Jazari Walker?
Yes, sir.
And how old are you, ma'am?
I'm 34.
And your present address? 2139?
2129.
29, okay.
Yes.
And we're here for an initial hearing on battery. Mr. Prosecutor, can you advise this young lady of what she's been charged with and the possible penalties?
She is charged by way of information that alleges that on April 13, 2026, LaPorte County, state of Indiana, the defendant unlawfully, knowingly, or intentionally did touch the person of a Daniel Redmond in a rude, instant, or angry manner by approaching the driver's side front door of a vehicle occupied by him with the driver's window down. She spit in the direction of Mr. Daniel Redmond and landed on the lower side of his face. That is a Class B misdemeanor. Class B misdemeanor is 180 days LaPorte County Jail and a $1,000 fine. That charge was elevated in the fact that it was in a rude, instant, or angry manner by placing bodily fluid or waste on another person. That is also a Class B misdemeanor. Class B misdemeanor, again, judges 180 days LaPorte County Jail and a $1,000 fine.
Ma'am, do you understand the charges and the possible penalties?
Yes, sir.
You folks wish to be heard?
Yeah, but because of the situation.
Okay.
And it's like, even while she's locked up now, she's sending people to our job to come see about us. She's having people contact us. And we want our protection order, like, on our family as a whole.
Mr. Galanos?
We're looking for a no contact order.
All right. And I'm sorry, ma'am, your name is?
Veronica McCormick.
Standard bond, Judge.
Your Honor, probation is asking for a hold. Okay.
Okay, one at a time.
Sorry.
I'm still on McCormick. I'm sorry, probation?
Probation would be asking for a 15-day hold, Your Honor.
Correct, I have been advised of that.
Why is that?
Just a minute, ma'am, take your time.
And I have one more thing, Judge, I'm sorry.
Hold on, ma'am.
Just take her, bro. They just take her, bro. They know what the other, bro.
She's been in here for
I've been here for 2 weeks.
Yeah, we do that, just they want, for them, just the one that.
Okay, ma'am, first of all, I'm going to advise you that probation has asked for a 15-day hold, so you're going to be placed on a 15-day hold. Second of all, I want to advise you that the court's issuing a protective order for Veronica McCormick and her family Do you understand what a protective order means?
I think I have an idea.
All right, it means you can't contact her in any way directly. You cannot have anybody contact her or her family on your behalf. No texting, no Facebook Messenger, no social media. You stay away from her until the protective order is dissolved. Do you understand me?
Yes.
Ms. McCormick, I would like for you, when you leave,
Zach, do not burn Pennsylvania down. I happen to like Pennsylvania. So when you come to Pennsylvania, you leave it just the way you found it, sir.
here to go up to the 3rd floor and ask for the victim advocate.
I mean, you were just in Florida and there was a ton of fires down there. I'm not saying you caused them, but I'm not saying you didn't.
They will obtain the names of all the members in your family so that that can be placed into the protective order. You understand?
Yes.
You have any other questions?
No, you answered it.
All right, 3rd floor, get off the elevator, turn left. Anything else from you, Mr. Delano?
Judge, the victim is a Daniel Redmond.
Right, so why is it?
I is McCormick.
Are you Mr. Redmond?
Yes, sir.
All right, so it'll be Mr. Redmond and his family to include Ms. McCormick, and then go upstairs and give the victim advocate all the names of the people in the family. Anybody have any further questions?
So it'd be under Mr. Redmond and his family.
Right.
As opposed to McCormick and her family.
Correct.
Okay.
So who's the protective order against now?
Mr. Redmond and everybody in his family, including Ms. McCormick. You understand?
Mm-hmm.
All right. Any other questions?
So I don't have a bond?
Your bond was previously set by the court at $300, but you have a you have a 15-day hold. So you're not going anywhere in 15 days. What do you plan to do for an attorney?
I guess I'm gonna get an attorney.
You're going to need an attorney?
I'm gonna get one. I'm gonna hire one.
I think you're going to hire an attorney. Okay. When are we resetting this young lady to?
So she'll be May 18th for her.
Court's resetting you to May 18th at 9 a.m. And the judge will then address any pending issues at that time.
So then that means I'll get a bond on May 18th.
I'm sorry?
May 18th, I'll get out.
She'll get a bond on the 18th.
Correct.
You get a bond.
Thank you.
It's stupid.
Thanks.
All right.
State of Indiana versus Angela Struff, 2411 CM 2708, initial hearing on petition revoke.
Are you Angela Struff?
Yes,
Am I pronouncing that correctly?
Strife.
And how old are you, ma'am?
I am 27.
And your current address? You are here. Apparently she was picked up on an FTA, is that correct? Yes, she failed to appear 3/31/26 and was picked up on 5/4 of 26. Ma'am, why weren't you in court?
I had missed it. Our vehicle was broken down at the time. We had just recently got it fixed. It needed a new alternator. I tried to call in advance and notify that I wouldn't be there. I also called my attorney, Paycheck, and told him that I wasn't going to be available to make it. Because I had paid attorney Paycheck.
All right, but you did try to contact the court and Mr. Pajak ahead of time?
Yes.
She has a warrant. It's only a shoot warrant. She has a warrant.
Okay. Well, it would appear that the warrant was issued because you have another warrant pending.
Yes, in Porter County.
All right. I'm going to set your bond for the failure to appear at $500.
Okay.
When you bond out, then you're probably going to wind up going to Porter County. So talk to Mr. Pajak about that. And we will reset you to
We'll do June 16th at 12:45.
June 16th at 12:45. That'll be in the magistrate's court next door. Make sure you appear if you bond out.
Okay.
Hedwig,
Thank
thank
you.
you, thank you.
Yeah.
17 months. Woo! That's awesome.
State of Indiana versus Dana Shields, 2406 F6838. Petition revoked.
No, I'm good so far, thanks.
Yeah, I
Mel,
didn't
thank
hear
you
that. I'm
so
sorry.
much. 21 months. Thank you.
Are you Dana Shields?
Yes.
And how old are you, ma'am?
34.
I'm sorry?
34.
34? And what is your address?
11199 West
Do you have a lot number on that address?
65.
I'm sorry?
65.
Thank you. The prosecutor's handed me a petition for revocation of suspended sentence. Listen as he explains to you why that petition was filed.
Can I ask the court to read it?
Certainly. First petition for revocation of suspended sentence. Susan Snyder states that you were placed on probation on September 8th, 2025. One of the rules of probation, condition 7, says that you shall not use, purchase, or possess illegal drugs or illegally obtain prescriptions, nor will you visit any place where illegal drugs are used, possessed, sold, or dispensed unlawfully. You shall provide verification of any prescribed medications. You tested positive for an illegal drug, methamphetamine, on the 24th day of March, 2026. Do you understand that?
Yes, I understand.
All right, I'm going to enter a plea of not guilty for you. Appears probation has a recommendation of 60 days LaPorte County Jail and complete substance abuse counseling.
I started substance abuse counseling. My probation officer said that she wasn't requesting a 15-day hold and that I'd have a bond. And I started through Swanson Center substance abuse counseling already.
Well, there was no hold that was placed, Your Honor, being that there was no new offense. She was picked up on the warrant, on the violation. So at this point in time, the probation would be in agreement with setting a bond today.
Okay. All right, ma'am, I'm going to set your bond at $500 cash only.
Can it be the $300 bond that was initially on the charge? I can't afford 5. I can do 3.
Well, I'm sorry, ma'am, you tested positive, you violated term of probation, your bond will be $500 cash. Do you have an attorney on this case?
No, I have to get one. I spoke to Amy Kameen about it so far. That was all I've gotten done.
All right, well, I suggest you contact an attorney and we are resetting you to
June 16th at 12:45.
June 16th at 12:45. That'll be in the magistrate's court. If you bond out, make sure you appear. Any questions?
That's it.
Thank you. Go ahead.
State of Indiana versus Dayton Jarnigan, 2604 CM 956 will be heard on issue of bond.
Well, first of all, we have to do the initial hearing on the invasion of privacy, correct?
Correct.
Are you Dayton Jarnigan?
Sir.
And how old are you, sir?
57.
57?
Yes, sir.
Go ahead, find it.
And your address?
It's 3.
All right, we're here on an initial hearing on invasion of privacy. Listen to the prosecutor. He's going to explain to you what the charge against you is and the possible penalties.
Charged by way of information alleges that on April 20, 2026, LaPorte County, State of Indiana, the defendant unlawfully, knowingly, or intentionally did violate a no contact order issued as a condition of pretrial release, including release on bail or personal recognizance or pretrial diversion. That, Your Honor, is a level Class A misdemeanor. Class A misdemeanor is 1 year in LaPorte County Jail and a $5,000 fine.
Do you understand the charge and the possible penalties?
Yes, sir.
Are you going to hire an attorney?
I already have one. Scott Paycheck.
Okay. Criminal history?
Judge, $2,500 cash bond. I got 2604 CM 956 invasion of privacy, which is the current charge as a name misdemeanor. 2512 CM 3018 invasion of privacy is a class A misdemeanor. 2511 CM 2868 invasion of privacy, a class A misdemeanor. 2508 CM 1903 domestic battery is a level 6 felony. 2504 F6 521 domestic battery as an F6 felony.
Sir, I'm going to find you to be a danger to society and set your bond at $2,500 cash. And you are currently set on your other case for $629.26, and we'll set this case to follow. Any questions?
No, Your Honor.
Thank you. Go ahead.
State of Indiana versus John Van Sanders II, 2605 CM 1058.
Are you Mr. Sanders?
Yes, sir, I am.
And how old are you, sir?
28 years old.
Your address? Didn't we already hear that address today?
Yeah, my girlfriend, you saw her there.
And that's Michigan City?
Yes, sir.
You've presently been charged with assisting a criminal. This is your initial hearing. Listen as the state reads the charge to you and the possible penalties.
He is charged by way of information that alleges that on May 3, 2026, LaPorte County, the defendant unlawfully, knowingly, or intentionally is a person not standing in the relationship of a parent, child, or spouse to another person who has committed a crime or is a fugitive from justice who, with the intent to hinder the apprehension or the punishment of the other person that was denied an Angela Struff, was inside the 400 block of Johnson Road and did harbor, conceal, or otherwise assist the person. That's a Class A misdemeanor. Class A misdemeanor is 1 year in LaPorte County Jail and a $5,000 fine.
Do you understand the charge and the possible penalties against you?
Yes, I do.
State bond?
Judge, we have a pending charge of under 46 D03 2511 CM 2829 for theft as a misdemeanor, standard bond.
And on A, is that 605?
Yes.
All right, sir, I'm going to set your bond at $605 and we will reset you to
June 16th at 12:45.
June 16th at 12:45 in the Magistrate's Court. Do you have any questions?
No, sir.
All right. Thank you. You okay?
Yep, thank you.
Get too fast, just tell me.
State of Indiana versus Jarrett Smith, 2604 CM 906.
Are you Jarrett Smith?
Yes, I am, Your Honor.
And how old are you, Mr. Smith?
I'm 20.
20?
I'm 20 years old.
Okay.
Sorry, I'm just going to go back for a second. Scott Paycheck is his attorney. So Scott Paycheck is a public defender. I don't know if, do people ever just pay for public defenders, hire them as regular attorneys? Did that person hire Scott Paycheck, or is it, they had to have, because this judge would have appointed the public defender's office if they qualified. So I think that he hired the public defender.
Okay. And your address. Sir, you're here for an initial hearing on the charge of criminal mischief. Listen to the prosecutor and he's going to explain to you what the charge is and what the possible penalty is, okay?
He is charged by way of information alleges that on April 12, 2026, LaPorte County, state of Indiana, the defendant unlawfully, knowingly, or intentionally or recklessly did damage or deface property of another person. a gentleman's car window without their consent. That's a Class B misdemeanor. Class B misdemeanor is 180 days LaPorte County Jail and a $1,000 fine. That charge was enhanced because the pecuniary loss was at least $750, but less than $50,000 in cash. The approximate value is $800. That made it a Class A misdemeanor. Class A misdemeanor is 1 year in LaPorte County Jail and a $5,000 fine.
I went to Jamaica. Oh my gosh, I'm echoing bad now. Never mind, I need to fix my audio.
You understand the charge and the possible penalty?
Yes, I do.
Okay. It's my understanding you have two theft charges pending in Porter County?
Yes.
I went to Jamaica on my honeymoon in 97, so a long time ago. And we stayed at the Sandals, the resort Sandals. And inside the resort, I paid a woman $40. Now, this was 1997, so $40 was different than $40 now. Paid her $40 to braid my hair like that. Then we go out on excursions and we go out to the towns, and it's poor. Like, people are living in literal shacks, just like pieces of metal just slapped together as houses. Poor. And the lady on the street was like, I would have done that for $1. I would have. But I did not like it. It was not. It didn't look good. It didn't feel good. It hurt. There was a lot of pain involved. And then getting it out when I was done. I left it in for a while, like a week or two. But then getting it out was such a pain. So I never, ever, ever did that again.
Okay. Other stated on bond?
Judge, your discretion, standard bond.
All right, sir, I'm going to set your bond at $605.
I want to ask you, Judge, is there a possibility we could maybe lower the bond? I don't have 600 on hand, or could we possibly OR me?
Judge, in light of this Porter County case, we would be objecting.
Yes, I agree with the state. Given the fact that you've got the two pending over in Porter County, I'm not going to reduce the bond from the standard bond. Do you intend to hire an attorney?
Yes, I do.
All right. We are going to reset you to
June 22nd.
June 22nd, 2026 at 9 a.m. If you bond out, you make sure you appear. Okay?
All right.
Thank you.
State of Indiana versus Jesse James Burke, 2303 F6 361.
Are you Mr. Burke?
Yes, Your Honor.
And how old are you, Mr. Burke?
34.
And your address?
323 Oakside Avenue.
Okay. Your telephone number?
269 2.
And did you read or see a video on your rights this morning?
Sure.
Okay. You have any questions?
Well, I wanted to say that I am the sole provider for my household. I have a fiance, 12-year-old stepson, and I was hoping to possibly get OR today. I know that you see my case is a little old, and I should have been handled this a lot sooner. But if you think about it, though, I have stayed out of trouble for 3 years. I go to work and I come home, and that's all I've done.
Okay. Mr. Prosecutor?
Your Honor, case was, he failed to appear. The case has been set on multiple occasions, and we're here always for status of counsel hearings. As for standard bond, the failure to appear is troublesome.
Why did you fail to appear on December 22nd, 23?
Your Honor, I believe that you were the prosecutor in my case at the time. What had happened was it was around Christmas time, and usually the court cases were going later in the day, like 1:30, 2 o'clock. And for some reason, it was an early day where I was having car problems. And then I finally had gotten a ride, and I was at the courthouse 10 o'clock, and I seen you come outside and you were smoking a cigarette. And
guilty as charged.
So you see that I'm not just lying about this. So I went up there. I tried to knock on the door. I talked to the county clerk. She kept giving me a voicemail, and I kept pleading on the voicemail, hey, please call me back. I'm trying to get this taken care of. I didn't mean to show up a little late. It was like 10 a.m. and court was starting at 8.
Well, court starts at 9. We may have gotten done early. But why didn't you get a hold of somebody in the last 3 years?
Well,
I remember the details pretty well, I must say.
So that's what I'm saying. I was afraid. I'm the sole provider of my household.
All right.
Only depends on.
Take a break. Here's what we're gonna do. You're gonna get an OR today, which I rarely do, but we're gonna reset you, and you're gonna make sure you appear in court. Do you have an attorney?
No, not yet, but that's why I was hoping to get the OR so that I could hire my own attorney.
All right. I'm going to OR you.
Wow, he got an OR. Good job, sir.
And we're going to reset you to
June 22nd.
June 22nd, 2026 at 9 a.m. 9 a.m. Got that?
Yes, sir. I appreciate it.
Don't miss it.
I won't. I'll be there.
All right. You're dismissed.
All right.
State of Indiana versus Keith English, 2502 F6 200, 2506 CM 1382. Petition to revoke. So. Like to be heard on the issue of bond.
Are you Mr. English?
Yes, sir.
And how old are you, Mr. English?
52.
0913?
Yes, sir.
All right. You have before you a second petition for revocation of suspended sentence. But before we go into that, did you read or see a video on your rights this morning?
I did, Your Honor.
Did you have any questions?
No, sir.
All right. Listen to the prosecutor as he explains to you the second petition for revocation of suspended sentence.
He was placed on probation by this court on November 3, 2025, and placed on probation. He executed written conditions of probation. One of the conditions he executed was condition number 7 that he acknowledged that says you shall not use, purchase, possess illegal drugs or illegally obtain prescriptions, nor will you visit any place where illegal drugs are used, possessed, sold, or dispensed unlawfully, and shall provide verification for any prescribed medication tested positive for illegal drugs, benzoylecgonine, cocaine, and methamphetamines on the 21st day of April 2026.
Do you understand the reason for the revocation?
I do, Your Honor, but I really got to say that them drugs aren't what was in my system.
Well, we'll save that for another day. Or do you have an attorney, or do you intend to hire an attorney?
I plan to hire one.
I'm sorry?
Plan to hire one.
You're going to hire one?
Yes, sir.
All right, your other case is set for May 19th, 2026. So we are going to set this to follow.
Your Honor, I got an appointment at the Swanson Center the 7th to have a drug evaluation for the first violation.
Well, you're currently set for May 19th, 2026 at 12:45 on your other case. I'm setting you for that same time on this case. You'll be at May 19th at 12:45, and I'm going to set your bond at, do you have a recommendation, State?
Judge, he's on probation. I would say $1,000 cash bond.
Your Honor,
I'm sorry?
I was just going to say, I got like $550.
Excuse me.
Has an extensive history, Judge.
But I make it to court every time.
but he was on probation on a suspended sentence.
I'm on a misdemeanor probation and a drug test. Come on, man.
Okay, all right, hey, calm down and take a break, okay?
Yes, sir.
Ma'am, do you wish to be heard?
Yes, he's our sole provider. Him and his mom's sick, and he takes care of me and his wife. If we can, I don't have $1,000 to get him out. I mean, if we can at least do like 500 or 600, I can get that, please.
All right, here's what I'm gonna do. I'm gonna set the bond at $600. Your case is set for 5/19/26 at 12:45 p.m. Do you have any further questions, sir?
Babe, you coming up here?
Yes.
All right. Thank you, Your Honor.
Your Honor,
That's it.
is that bond for both revocations?
No, I'm on the other.
That's aggregate jail.
I have an F6 short cause 200 and then a CM short cause 1382, both revocation.
Yeah. Aggregate.
Yep, thank you.
State of Indiana versus Robert Lawrence Fisher III, 2505 F6 604.
I'm sorry? Are you Mr. Fisher?
Yes, Your Honor.
And how old are you, Mr. Fisher?
So I think this judge is retired, right? And he's just here helping out for the day. That's why he's like so laid back and just he's gotten in some crazies today. It's like the other judge knew he was taking off and said, okay, schedule these people for this day.
38 years old, Your Honor.
All right, and you're at. Okay, we're here for a status of counsel. Have you hired an attorney yet?
No, Your Honor. I've been here since about, say, March 17th, and I haven't been able to have any outside contact.
Well, I'm assuming you can use the phone to contact an attorney.
I'm indigent at the moment, Your Honor.
Do you have any family members that can help you out?
I've sent letters to my dad. I have no idea if he's actually he hasn't reached out to me.
All right. When did you last work?
It would have been about November. I'm self-employed.
So November of 2025?
Why is it the retired judges are always the best?
Correct, Your Honor. Right before the snow hit, I was doing a fall cleanup.
What kind of work do you do?
I guess you call it handyman work, landscaping, general odds and ends, stuff like that. I help my grandpa out because he's got contracts out through Long Beach and stuff.
Okay, take a break for a second, sir.
Recommendations based on a positive drug screen. He's been in jail. Our recommendation was 60 days in jail. He's been in jail since 3/17. If he'd be willing to admit, get credit for time served, and then continue on probation as originally sentenced.
Okay.
I don't know if you're okay
That
with
sounds like a very good deal, sir.
All right, sir. Mr. Probation has approached and have stated that their recommendation was that you would spend 60 days in jail for this violation. You were taken in custody in March, so you're close to the 60 days. The probation department has stated that if you're willing to plead guilty to the probation violation, they will allow you to have considered time served and you would be released today. Is that something that you're interested in, or do you want to wait and hire an attorney?
I'll admit to I was wrong, and I did do that, sir. Yes. Please continue.
Do I fill this out?
Well, trying to think, how many days?
Whatever, we're actually.
Folks, calm down, please.
Say or those.
Yeah.
And then you say continue on probation.
What day did he go into custody?
March 17th.
There you.
60 would be 30 days.
I have 48 days. 48 days, and so times 2 is 96.
I'm
So
sorry?
96 days with good time.
48?
48 times 2 would be 96.
This was a violation of probation, right?
Correct.
Bren, you want to see what I got today? I ripped it because I already showed it earlier. Australian candy. Violent crumble. Okay, it's violet crumble. But I've every single time read it as violent crumble. It's the whole reason I got it, because it looked like that first word was violent. It's honeycomb in chocolate. Anyway, I was thinking about that. Guys, we should start a new business. I got a better business idea than any of my other ones. The reason I got this candy bar, the reason why I looked at the candy bar at first was because I thought it said violent crumble. And I'm like, bet, I want that. I don't care what it is. Then when I got closer, it said Australia's violet crumble. And I was like, oh, people on the stream would love that. It's Australian candy. But violent crumble, I bought it because I thought it said violent. We need to make a line of candy bars that are just, these crimes. Aggravated assault caramel. Double homicide chocolate. We would sell 1 million of them, right, Snoopy? Right? Somebody get on that. Someone head it up. We'll all give you money and we'll start a candy company. We won't use Hershey's because I know internationally people do not like the taste of Hershey's chocolate. So we can use Cadbury. I'm fine with that.
How much probation he's on?
He's on probation until March 5th of next year.
So are we applying because he technically has
Well, it would
36 days.
the way that we do that is if there's more like if you would ever fully execute the sentence, we would subtract those 96 days off the original sentence. So he's just going to continue on to the original set date of March 5th, 2027.
Yeah.
Well, we're giving him 96 days, 48 served, 48 good time, correct?
Correct.
Okay. We're throwing out a different number.
If just a different person. Every time I say, let's start this business, if one person would head that up, we would have like 18 businesses going right now. And Brad, when you have 18 different businesses, one of them can be food, it's fine.
You're good with it?
Yes.
Okay.
Whatever you say. We're not doing that.
What's that?
So we don't want to calculate that.
We don't do math? And he continues probation to 3/5/27?
Correct.
All right, sir. So the agreement that has been proposed by your probation or by probation is that you are pleading guilty to the probation violation. You are being sentenced to 96 days LaPorte County Jail. You're getting credit for 48 days of incarceration and 48 days of good time. You are going to continue on probation to March 5th, 2027. Do you understand?
Yes, Your Honor.
And that would be time served, Your Honor?
There's only one way to solve this, ladies. There's just one way to solve this. You'll have to come to to Pennsylvania and each rent a little kitchenette. I will be the judge. Make y'all stew. I will taste it and be the judge of the carrots and the potato sogginess.
Yes, I have to add
Uplift bar.
a couple things to this form. Was that a first violation?
I believe so.
To my knowledge, it was my first violation, Your Honor.
Okay, I just want to make sure we get the paperwork right. Okay, do you understand that? Do you wish to speak to an attorney, or you rather enter that today and go home today?
I'd rather enter it and continue on, Your Honor. I appreciate it.
All right, good luck and stay out of trouble. And probation, when do you want him to contact?
His probation officer is Mrs. Snyder, and she's out of the office until Wednesday, so you need to report in person on Wednesday.
Do you understand that?
Yes, Your Honor.
Michigan City Courthouse, come see Ms. Snyder on Wednesday, or you'll get another rebel and you'll be right back where you're at.
I don't want that, Your Honor.
All right, then probation will see you on Wednesday and you're dismissed.
But he really does
Appreciate
want
you. Thank
that,
you, Your Honor.
because Wednesday
bet.
came and went, and I bet he didn't show up.
State of Indiana versus Yvonne Taylor, 2308 F6 1214.
Are you Mr. Taylor?
Yes, Your Honor.
And how old are you, sir?
30 years old.
And your current address? Okay.
I sent his attorney the Zoom link.
I'm sorry?
I sent his attorney the Zoom link, but he has.
Sir, you have an attorney out of Crown Point, is that correct?
Yes, Mark.
Okay.
Paycheck coming for him last time.
Well, he's not here today. Neither Mr. Pajak nor your attorney are here.
That's just sad, because Reese's peanut butter cups are the best. And you don't have Reese's peanut butter cups. And the chocolate, okay, I get it, but the filling is so good.
What do you plan? Well, you have an attorney.
Yeah.
Reset him to next week.
Yeah, I was up in Superior one. They got me waiting for my acceptance letter to go to rehab.
Oh, that's awesome.
All right.
Good.
Well, but I hate to do anything without your attorney. So I think what we're going to do is we're going to reset you to, make it next Monday or next Friday.
Let's do next month.
All right. And that date will be
The 11th.
All right.
All right, sirs. We're going to give notice to your attorney. We're going to show that you appear by video. Your attorney fails to appear, and the notice will be issued for your attorney to appear on May 11th, 2026 at 9:00 a.m.
All right. Thank you.
Thank you. Have a good day.
Yeah.
Your Honor, that concludes the jail call.
Great. Jail, I think we're done.
Thank you.
Thank you. Thanks for being patient with me.
Bobby grabbed your butt.
State of Indiana versus Thomas Ankron, 2409 F6 1264.
What do we do?
I believe counsel is going to ask for a
Good morning, counsel.
additional time.
Yes, we're going to ask that this be reset for a change of plea. We do not have terms yet, but I believe we'll go through those fairly quickly.
All righty. How much time do you think you need?
Sometime in June.
Got in.
29th?
June 29th at 8 a.m. I'm sorry, 9 a.m.
Maybe. I can do that, Charlie.
Okay. We'll see you back here then.
Thank you, sir.
State of Indiana versus Elliott Cummings, 2601 F63.
Good morning, Mr. Howes. How are you?
Very good, thank you.
Good. What do we got going on today?
Plea negotiations are ongoing. I would ask for a new status date of June 29th.
That work for you, Angie?
Yes.
All right, we will reset to June 29th, 2026 at 9 a.m.
Thank you. You're welcome.
State of Indiana versus Terry Jameson, 2511 CM 2886, 2602 CM 303.
Mr. Jameson is present. It's going to be the same request, Your Honor. Had some negotiations with Mr. Galanos on this. We need to work a little bit more on this matter. Would ask for June 29th on defense motion.
Any objections, State?
No, sir.
All right, we're resetting this matter also to June 29th, 2026 at 9 a.m.
Thank you.
Make sure you're here, sir. Listen to your attorney.
That's all I have for you.
I'm going to enter on Angelica de Jesus.
That pro se?
Yes.
State of Indiana versus Angelica de Jesus.
Initial hearing, Your Honor. I'm entering my appearance.
I'm sorry, 2604 CM 909 and 2604 CM 908.
Go ahead, Mr. Howes.
Initial hearings, Your Honor. Entering my appearance on both matters.
All right, are you waiving initial or do you want to?
I would move to waive the initial, Judge, and set the matters for status on June 29th.
So
This is magistrate, so
Oh, okay.
do you want Tuesday?
Let me look. June 30th would work.
Okay, that's good, at 12:45.
Very good. Thank you.
thank you, Mr. Howes. I'm showing your appearance entered, initial hearing waived, and what was that date?
That was June 30th at 12:45.
Okay, thank you.
All right, thank you.
State of Indiana versus Candace Hernandez, 2604 CM 910, 2604 CM 907.
Mr. Coleman, good morning.
Morning, Your Honor.
How are you this morning?
Doing fine and yourself?
Good, good. What do we have going on with Ms. Hernandez?
Your Honor, this is an initial hearing. I'd move to waive the initial hearing. I'll be entering my appearance. I'll follow this up with a written notice. If we could have this, I think we'll have it resolved. If I could have this continued to say June 30th. I believe this is also magistrates.
It is.
That'll be June 30th at 12:45. Initial hearing waived. Mr. Coleman appears on behalf of defendants. Anything else on this case?
No, Your Honor.
All right, ma'am, listen to your attorney, show up when he tells you to show up, okay?
Oh, yeah.
Good.
State of Indiana versus Lola Price, 2512 CM 3036.
Lola Price, are you present? Mr. Coleman?
Your Honor, I've spoke with Ms. Price in the past several times. I believe last time I spoke with her, she had requested a continuance due to some family matter. I don't know why she's not here today. I did let her know today's court date. We are still working out a plea with the state at this moment. My intention was to set this for a trial today, but obviously can't do that without her here. I requested a 30-day continuance to try to get in touch with her again.
And Dave?
June 8th.
All right, the court's going to reluctantly set this matter to June 28th, 2026. It's going to show the defendant fails to appear. There will not be a warrant issued, but if the Defendant FTAs on 6/8/26. A warrant will be issued over Mr. Coleman's objection.
Thank you, Judge.
All right.
State of Indiana versus Naomi Smith, 2601 CM 61.
Mr. Coleman?
Your Honor, I believe that the state has filed a motion to dismiss on this matter.
Does the state do that?
That's what I've been told. So moved.
You agree with that motion?
It was filed on May 1st.
Yes, I do.
All right, matter dismissed.
Yeah.
Oliver Nendinger versus State of Indiana, 2604 XP 26.
Good morning, Mr. Cerruto.
Good morning, Mr. Ambers. How are you?
I'm good. And you?
Oh.
And we're both sans Walker today. That's a good sign.
Yeah.
Last time Mr. Cerruto and I were in court together, we were both in walkers.
Yeah, that was pitiful.
I tried to get a picture, he refused. What are we doing today, Mr. Cerruto?
Your Honor, I filed for a motion for expungement. Attached to my motion is consent from Mr. Fredoso. Not only allowing us to do it a little bit early, but he's having no objection to the expungement. So we'd ask the court to grant the expungement.
So granted.
I have a form of order, but I filed one with the.
Right.
Let's break that for you.
What was attached?
You have that.
Another?
Signed, sealed, delivered.
They're lyrics to a song.
I believe so.
Well, thank you very much.
You bet.
Nice to see you.
You too.
Thank you.
State of Indiana versus Miguel Ruiz, 2501 CM 84. Right.
Mr. Beal, how are you this morning?
Hey, sir, it's good seeing you. This is the end of a pretrial diversion. The $300 bond was used to pay the fee, then I paid the remaining $34 this morning.
Okay.
So that should take care of it.
So this is the tail end, so it's dismissed?
Salty, thank you
need
so much.
anything else for
Thank you.
that?
I appreciate it.
Okay.
State of Indiana versus Calvin Stampley Jr., 2109 F6 1235, 2110 CM 2802, 2406 CM 1260, 2406 CM 1295, 2409 CM 2140, and 2504 CM 969.
Judge, we just reached a plea this morning on this. So we'll need some time for victim notification. And, Calvin was here this morning. He lives in Maryville now and had a chance to go back to work. So I told him to come back June 29th. That works. Okay. There are a couple different victims we have to notify first.
All right, all cases reset to June 29th, 26, 9 a.m. pursuant to defense counsel request. Anything else on that matter?
No, Your Honor.
Rick? Go ahead.
I think I'm done with you.
You have a Laura Pratt? No, it might be in the first state. She initially filed for a stay expungement. It's on my case today. Yeah,
So she's in close counsel.
Yeah.
State of Indiana versus Laura Pratt. I'm sorry, Laura Pratt versus State of Indiana, 2602 XP 6.
What do we have, Mr. Beal?
Judge, I entered for Miss Pratt and filed an amended petition to help her get this resolved. Her last conviction was in 2014 for a misdemeanor disorderly conduct. There's been no conviction since, no arrests
Since 2017, she's completed everything in the past as far as probation, payment of fines and costs, just asking for an expungement of her record. She's working as a realtor now here in Michigan City and like to clean it up.
State any objection?
No, sir.
Okay.
I brought up one more.
So one?
That's probably one that she submitted. This one's probably a better one.
Let's pitch that one.
Yeah. Thank you.
State, I can't remember if I asked, do you have any objection to
No.
this?
Are we good? I'll send you a couple other things.
No, we're both leaving for these 2 weeks.
I'll meet you there.
All right.
Anything else for Ms. Pratt?
There you're on.
Well, hopefully her new career works out for her. Quite a few charges expunged there.
State of Indiana versus Saldotian Abdelnabi, 2404 CM 761.
Sadain Abanabi, if I'm pronouncing that right? Supposed to be status counsel.
Failure to appear, move for warrant.
So issued.
State of Indiana versus Michael Lane Abner, 2605 CM 1053, initial hearing.
Are you Mr. Abner? Have a seat, sir. And
0667.
all right, you've been charged with resisting law enforcement and public intoxication. On the way in, did you grab a waiver of rights form?
Yes, I signed it and left it by on the podium.
Okay, can you grab that and give it to Mr. Galanos for me? Oh, you can give it to Mr. Kiner. All right, sir, Mr. Kiner's handed me the waiver of rights form where your name has been filled in and there's signature and date on the back. Did you sign this document?
Yes, sir.
Do you have any questions about your rights? All right, listen to the prosecutor. He's going to tell you what you've been charged with and the possible penalties. But before you start, Mr. Galanos, anybody that's here for initial hearing, your first time in court, make sure you grab a waiver of rights form, read it and sign it and have it ready to bring up with you when you come up. Mr. Galanos.
Judge, he's charged by way of information that alleges as follows. It states that on or about May 3, 2026, LaPorte County, State of Indiana, the defendant unlawfully, knowingly, or intentionally did flee from a law enforcement officer after the officer has, by visible or audible means, including the operation of that law enforcement officer's siren or emergency lights, identified himself or herself and ordered the person to stop. That is a Class A misdemeanor. Class A misdemeanor is 1 year, LaPorte County Jail, and a $5,000 fine. He is also charged with, on that same date and time, with appearing in a public place or a place of public resort in a state of intoxication caused by the person's use of alcohol or a controlled substance, and harassed, annoyed, or alarmed another person. That is a Class B misdemeanor. The B misdemeanor is 180 days LaPorte County Jail and a $1,000 fine.
Do you understand the charges and the possible penalties?
Yes, sir.
Are you going to be hiring an attorney?
Yes, sir.
All right. Let's reset you to, do you permanently live in Kentucky or are you living here for a while?
I travel for work.
Okay. So you'll be around?
Yes, sir.
Okay. We're going to reset you to,
Let's do June 12th.
will you still be in the area on June 12th?
Yes, sir.
Okay. That'll be at 9 a.m. here in this courtroom. If you hire an attorney in the meantime and he gives you a different date, follow your attorney. But if you don't get an attorney hired or you don't hear from an attorney as far as a new date, Make sure you're here on June 12th, 2026, okay?
Sir.
All right, you're dismissed.
State of Indiana versus Randall Childress, 2605 CM 1054, initial hearing.
Randall Childress?
Yes, sir.
Okay, come on up, sir. Give your form to Mr. Kiner. Okay, sir, your age?
79.
All right, your address?
3121 Wabash, Michigan City, Indiana.
Okay, phone number?
219.
All right. Mr. Kiner handed me an advisement of rights form. Is that your signature?
Yes, sir.
Do you have any questions about your rights?
No, sir.
All right. Listen to Mr. Galanos, and he's going to explain the charges to you and the possible penalties.
He is charged by way of information that alleges that on May 1, 2026, in LaPorte County, state of Indiana, the defendant unlawfully, knowingly, or intentionally operated a motor vehicle with 0.15% or more blood alcohol content. It was 0.156%. That is a Class A misdemeanor. Class A misdemeanor is 1 year in LaPorte County jail and a $5,000 fine. He is also charged with operating a motor vehicle while intoxicated in a manner that endangered a person. That is Class A misdemeanor also. Those are the two charges.
She doesn't like them low because
They never get set
they
up.
never work great and the track launches no better.
All right.
So
Do you understand the charges and the possible penalties against you?
Yes, sir.
Okay, excuse me for conferring with staff, but I'm a pro tem judge, which means I only fill in for judge once in a while. And apparently they are no longer, lucky for you, assigning a home blow or a watch that tracks if you use alcohol. So for now, so we're not going to do that. That's a bit lucky for you. Do you intend to hire an attorney?
Yes, sir.
All right. And we're going to reset you to
let's do July 6th.
July 6th at 9 a.m. If you hire an attorney gives you a different date, listen to the attorney. If you do not hire an attorney or you don't hear of a different date, make sure you're here at that time. If you're not here at that time, a warrant can be issued for your arrest.
Yes, Your
All
Honor.
right? And please do not drink and drive. Okay?
Never happen again, sir.
I hope not. Thank you.
Thank you.
State of Indiana versus Adriana Dominguez, 2603 CM 729, initial hearing.
Are you Ms. Dominguez?
Yes, sir.
Okay, and your address is, ma'am?
5.
Did you, Mr. Kiner's provided me with this advisement of rights. Is that your signature? Do you have any questions about the rights? All right, listen to Mr. Galanos. He's going to explain your charges and possible penalties.
Yes.
She is charged by way of information that alleges that on March 29, 2026, LaPorte County, state of Indiana, the defendant unlawfully, knowingly, or intentionally did operate a motor vehicle upon a highway. It was a Chevy Malibu motor vehicle, having never received a valid operator's license and not being exempt from those requirements under section Indiana Code 9-1-4-27. That's a Class C misdemeanor. The Class C misdemeanor is 60 days in LaPorte County jail and a $500 fine.
Okay. Do you understand the charge against you?
Yes, sir.
Do you understand the possible penalty?
Yes, sir.
Do you intend to hire an attorney?
I would like a public defender appointed.
Well, you just were charged here on, well, I guess this goes back to March. Are you presently working?
Yes, sir.
And where do you work at?
At Juvenile Justice Center,
Are you full-time or part-time?
full-time.
Well, given the fact that you got full-time employment, I'm today not going to give you a public defender. This matter's been pending since March. I'm not sure why your first appearance took so long. Well, I guess it was just March 29th, 26th. So that I guess I understand. We're going to deny your request for a public defender at this time. Perhaps the sitting judge will take it up in the future, but with a full-time job, I am not going to grant the public defender. So we're going to set you for a status of counsel on
June 23rd at 12:45.
June 23rd of 26 at 12:45 a.m. That'll be in the...
All right, guys. Cloud's here. We got to go. No. Cloud just conveniently came in at the very end of the stream. Thank you so much for coming out today, guys. I really appreciate it. It's Friday. Go out tonight. Go dancing. Have some fun. Don't get arrested. Judges won't be in until Monday. And I shall see you tomorrow morning. I hope you guys have a great day. Thank you so much, guys. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time.